Deputy Public Defender Oscar B. Rowe with another lesson for Dr. Field's criminal law classes. This one is on using self-defense. Under California self-defense law, a person has a basic right to defend himself and others against threats of harm. This concept is explained in California Criminal Jury Instructions Cal Crim 3470, right to self-defense or defense of another, non-homicide. The defendant acted in lawful self-defense or defense of another if 1. The defendant reasonably believed that they or someone else was in imminent danger of suffering bodily injury or was in imminent danger of being touched unlawfully. 2. The defendant reasonably believed that the immediate use of force was necessary to defend against that danger. And 3. The defendant used no more force than was reasonably necessary to defend against that danger. If you reasonably believe that someone is about to attack you or another person, California's self-defense law allows you to use enough force to prevent harm. If the court finds that a reasonable person in your position would have fought back the same way, your criminal charges should be dismissed. A danger is considered imminent when there is an immediate or present threat. People v. Aris, 1989. This is when a threat is happening right before you. An imminent danger cannot relate to something that may or may not happen in the future. For example, if you were at a bar and someone calls you and threatens to kick your butt the next time he sees you, you cannot preemptively go find him just to beat him up. Here are 5 key points about self-defense. 1. The force you use must match the level of threatened danger. 2. The danger does not need to have been real as long as your belief was reasonable. 3. You can use deadly force only if you reasonably fear great bodily injury or death. 4. California is a stand-your-ground state, so there is no duty to retreat from a fight. 5. California's castle doctrine lets you use deadly force against an intruder who breaks into your home. Self-defense serves as a legal defense to many criminal offenses, including murder, PC 187, or manslaughter, PC 192, mayhem, PC 203, domestic battery, PC 243E, 1, assault with a deadly weapon, PC 245A, 1, and simple battery, PC 242, or simple assault, PC 240. Your home is your castle. California Penal Code Section 198.5 is the castle doctrine, which creates a legal presumption that a resident was in reasonable fear of imminent death or great bodily injury when they used deadly force against someone who unlawfully and forcibly entered their residence. This means the resident doesn't have to prove their fear was reasonable. The law presumes it under the specific conditions of a forceful, unlawful home invasion. California is a stand-your-ground state, meaning you do not have to retreat in order to lawfully claim self-defense, even if you had a means of escape. If you started a fight, meaning you were the aggressor, you can assert self-defense only if you made a good faith effort to stop fighting and indicated this to the other person, or you initially attacked with non-deadly force, and the other person responded with deadly force. In California, you never have to prove you acted in self-defense. Instead, once you claim to the court that you acted in self-defense, the prosecution bears the burden to prove beyond a reasonable doubt that you did not act in self-defense. Self-defense is considered an affirmative defense. This means that you are admitting you broke the law by inflicting physical force on someone, but your actions were justifiable under the circumstances. In California, you are legally justified in using deadly force in self-defense under certain circumstances. You reasonably believed that you, or someone else, was in imminent danger of being killed, suffering great bodily injury, or being the victim of a forcible and atrocious crime, and you reasonably believed that you needed to use deadly force to prevent the danger from happening, and you used no more force than was reasonably necessary to keep the harm from occurring. You can use deadly force in self-defense, even if you were the original aggressor, provided you tried but ultimately failed to end the fight. California's flannel doctrine, also referred to as imperfect self-defense, applies when you kill another person based on an honest but unreasonable belief in the need to use deadly force in self-defense. To go into effect, the flannel doctrine requires a showing that 1. You believed that you were in imminent peril of being killed or suffering great bodily injury. 2. You believed that the immediate use of deadly force was necessary to defend yourself. And 3. At least one of these beliefs was unreasonable. So that is today's lesson on self-defense. I'm Deputy Public Defender Rowe. Hopefully you gained some knowledge from this lesson.